to, and I call the honourable member for Fowler.
Ask leave to the House.
Oh, sorry. Sorry, I put the question. All of that opinion say aye. To the contrary, no. I think the ayes have it. I call the honourable member for Fowler.
Thank you, Deputy Speaker. I ask leave for the House to move amendments 1 to 8 as circulated in my name together.
Is leave granted?
Leave is granted.
Leave is granted.
Thank you. I move amendments 1 to 8 as circulated in my name together. Deputy Speaker, the Family Law Act is already convoluted and arguably distressing enough for those involved. I hope that in bringing forward amendments, our aim should ultimately to simplify the processes currently in place and to reduce adversarial harm, especially on children. Family law is often a complex place, having to deal with people and parents who are hurt, emotionally fraught and struggle to hold things together as for their children's sake while going through a separation. I would like to make my position clear that my views on this bill is not to be taken as favouring mums or dads. This is not the point of this conversation. Children are at the centre of these amendments. While there are various proposed amendments, I would like to focus on the changes to Section 60cc, which are the factors in determining a child's best interest for considering parenting arrangements. Nearly 14% of my Fowler electorate are reported to have been divorced or separated, which is higher than the national average. Therefore, it's important for me to speak on this bill, and in particular for an electorate where more than 50% of our population speaks a language other than English. Proposed subsection 60cc3 is to be introduced to specifically to promote the best interests of an Aboriginal or Torres Strait Islander child, including the opportunity to connect with and maintain the child's connection to the child's family, community, culture, country and language. These are factors that I strongly resonate with and wholeheartedly support for our Indigenous children. However, I invite the government to give greater consideration to the best interests of children through a multicultural lens. I represent the multicultural heartland of Australia, where many of the children in my area grow up with a strong sense of cultural identity. However, children who have separated parents from different cultural backgrounds could miss out on this important part of the development. I believe it's in the child's right to grow up knowing their heritage, whether it be learning the language, attending cultural festivities or volunteering with community groups. The court must recognise this as a critical factor. My other amendments seek to broaden the definition of harm towards a child when the courts consider their safety. It's my hope that redefining it as other such forms of harm encapsulates certain behaviours that are inconspicuous and yet insidious. Furthermore, Amendment 4 will ensure the courts consider both ability and capacity for parents to care for a child, particularly as capacity could be far too broad when assessing the suitability of care for a child. In sum, I believe my amendments will safeguard the child's best interests when it comes to their parents' ability to care for them, but in particular their right to maintain their cultural heritage and have a strong sense of their own cultural identity. Thank you, Deputy Speaker.
Thank the honourable member for Fowler, and I call the Minister.
Thank you, Deputy Speaker. I thank the honourable member for her engagement with this bill. As the member has noted, it is expected that this bill will be referred to a committee, so the government won't be supporting these amendments at this time.